Good afternoon and welcome to day 4 of the Real Estate Academy Property Management course. This is also the 4th and final session of the course. We're glad you could join us. This is Victoria B. with the LTAP Center. And more importantly, I have my colleagues from the Real Estate Office on the webinar with me, Tyler Prose and Scott Recker. They will be your presenters for today. No poll, since we had some technical issues with that yesterday, but I do want to point out that in the handouts box, we do have a copy of today's slides. And thank you for those who've already said hi or hello in the question box. Glad you found it. That is how we'll be taking questions throughout the webinar today. So I'm going to go ahead and turn things over. If you're ready, Tyler.
Okay. Thank you,
Thanks.
Victoria. Well, welcome back. Thank you for making it back for the 4th day. I know it's a big time commitment. We're going to get right into it with Module 4, Extinguishments and Limited Access Modifications. We will be doing 2 quizzes and 2 case studies today, along with these 2 topics. Learning outcomes. You will be able to identify when to extinguish versus vacate an easement, prepare ODOT's Extinguishment of Easement Instrument, understand ODOT's limited access control, describe a limited access modification, and understand ODOT's limited access control. I already said that. Okay, extinguishments. Extinguishments of easements. If a disposal of a remnant easement will not adversely affect an abutting owner's use or access of the highway, disposal may be accomplished by extinguishment of the easement to the underlying fee owner. Before extinguishing an easement, the district must determine whether the extinguishment will negatively affect an abutting owner. If the district determines the extinguishment will negatively affect an abutting owner, the district must follow the vacation procedures we discussed yesterday. If you are extinguishing an easement to the underlying fee owner, you will do so at no cost. Extinguishment of easements are initiated at the request of the underlying fee owner. Upon receipt of a request for extinguishment, the district will secure a statement in writing from the requesting owner containing the location of the property and an identification of the easement to be extinguished. The requesting party must also supply the most recent deed of record to identify the current underlying fee owner. The district may also require the requesting party to provide a current title report, plans, surveys, and/or a legal description to process the extinguishment. After all necessary approvals have been attained, both in-house and external, the district will prepare and record the Form RE 63-1, Extinguishment of an Easement Instrument. It is a very straightforward instrument and looks very similar to the other disposal instruments. District shall retain a copy of the recorded instrument in the disposal file. The district will also indicate and note the extinguished easement on the right-of-way plans. Okay, that's all for our our easement part. We're going to get right into a case study about roadway vacation or easement extinguishing. As you see in the picture, there is a road that's highlighted in yellow. And then for the first question, we're assuming that a property developer has bought everything surrounded in blue. They've bought all these parcels here. It's been through all in-house reviews, all environmental reviews. ODNR has no use for it. Federal Highway has approved the sales disposal or the service roads disposal. No LPAs want to acquire the property. What is the best option to dispose of this property if someone owns the entire, if there's only one abutting owner? As the developer owns all the properties surrounding and accessing the service road and has stated they no longer wish to access the property via the service road, the district may extinguish the easement to the underlying fee owner. The underlying fee owner would be the developer. So that would be the easiest. In scenario 2, the developer owns a blue, but then there are 2 holdouts, the parcels in green, highlighted in green, parcels 6 and 7. That would change it just a little bit because there's more than one abutting owner. The answer, or if they want to dispose of that with multiple abutting owners, the district will vacate the roadway, which may involve damages to parcels 6 and 7, and access may be impacted. If parcels 6 and 7 have adequate access into the adjoining roadway to the south, they may be able to extinguish the easements to the underlying fee owner without any damages. Okay, now the steps you would follow if you are vacating the roadway. Step 1, you need to prepare a notice of vacation of right-of-way, form RE 74-11. It is prepared by the district and mailed to all abutting owners by certified mail, return receipt requested. It is also published once a week for 2 consecutive weeks in a newspaper or of general circulation in the county where the property is located. Owners whose place of residence is unknown or who have non-residential or non-residents of the state are specifically named in the notice of publication. The notice must be mailed by certified mail to the Director of Natural Resources to comply with the ORC. Notice fixes a vacation date not less than 20 days after the date of the final publication and sets forth procedures for filing claims for compensation and/or damages. The district receives all claims and enters the hour and day they received. If no claims are filed within the time period contained in the notice, the district office will complete the vacation proceedings. When claims are filed, district examines and orders appraisals for each. Appraisals are reviewed and, if awarded, is justified. FMVE will be established following standard appraisal procedures. Once FMVE is established, an offer will be made following established acquisition procedures. If damages are great, affected owners may also be entitled to relocation benefits. When agreements can be reached, a settlement and release of claims form RE63, negotiation summary report form RE60, and the negotiator notes form RE60-1 are completed. Payment is processed the same as all other right-of-way payments. When agreement cannot be reached, the form RE60, RE60-1, and RE61, appropriation attachment to negotiators' notes, are processed and completed the same as appropriation of highway right-of-way. Upon satisfaction of all damage claims, either through negotiations or court action, the district will prepare and execute a highway vacation instrument, form RE 74-42, for each parcel being vacated. The instrument shall be provided to all affected property owners and to the county recorder. The district shall retain a certified copy of the recorded instrument in the disposal file. The district shall indicate and note the vacated area on the permanent right-of-way plan and send a copy to the central office property management. If any of you went to the real estate summit that the real estate department puts on, it is at the church right here that is part of that parcel that we just talked about. The developer bought all of it, and if there's those 2 parcels that were holdouts are now O'Charlie's and part of Home Depot's parking lots. Now we're going to start a quiz on that stuff.
Hey, Tyler.
Yeah.
I got a couple questions that I'd like to address before you start the quiz.
Yes, sir.
Had a question that by law doesn't half go to each adjacent owner, and that would be correct if it was, for an example, when cities vacate alleys, that those vacations are usually, those alleys are owned in fee because it's usually a platted subdivision or something where the roadways are designated. the thing to remember is extinguishments and vacations are only when we have an easement on the property. So when we vacate an easement or extinguish an easement, it is to the underlying fee owner. So whoever owns under the area that we're going to vacate would get it. Whether it's just one property owner, it could be two property owners, but it doesn't have to be equal. So whatever the title work shows that the underlying fee owners are, that's who would get the vacation. It doesn't work quite the same way as like vacating alley, where half goes to each side of the center line of the alley or whatever. But because these are only easements, it's not in fee.
Right. You just need to see who is the underlying fee owner. That it always boils down to that.
Yep. Okay. That's the only question I had.
Okay.
That we had.
Yeah, let us know if you have any more questions. Okay, we're going to get to the quiz. Number 1, State Highway 321 is being moved from its current alignment, and existing roadway is going to remain open to the public. Once the state route designation is removed, the roadway will become a local road and ODOT will no longer maintain it. To accomplish this, the department will.
And you can put A, B, C, or D in the question box. I'm getting a whole slew of A's. Oh, got a C.
A is correct. You would abandon the highway. If you abandon it, it will go to the locals. Number 2, true or false? Roadway abandonments are not a real estate function. Instead, they are handled by the Office of Tech Services in central office.
We got a T in there. Lots more T's coming in.
Man, you guys are good. Yes, that is a T. That is true. That is handled through Dave Gardner now. Used to be Mike Greenwood, but he was recently retired. If you need his contact information, contact me and I will get it to you. Number 3, true or false? Since access rights will be impacted, all roadway abandonments will require that an appraisal be prepared to determine potential abutters damages.
We're getting a whole bunch of F's.
Man, that is correct. You do not always have to have, sorry, there will not always be damages. Number 4, when a district is vacating a roadway, they will prepare a notice of vacation of right-of-way, form RE 74-11, and have it advertised blank in a newspaper of general circulation in the county where the road is located.
We have a mix between C and D. It's evenly split right now amongst everybody who's sent it in.
It is always once a week for 2 consecutive weeks. We don't go twice a week. It just has to be in there once a week. What is the Ohio Revised Code for the minimum number of days after the last publication date of the notice of vacation of right-of-way before ODOT can establish a claiming deadline?
Well, so far we've gotten C, D, and A. Let's get some more answers in there and see if we can get a majority.
Okay.
Now we're getting more A's and D's. I think that C might have been left over from last time. It's a split between the A's and the D's pretty evenly.
Well, it is actually C. So if someone did do it, they were correct. It has to be 20 calendar days after the notice for the deadline. Number 6, in addition to being publicized in the newspaper, the notice of vacation of right-of-way is mailed to.
Everybody's picking A. Somebody just picked D. Now more people are picking D. It's a split between A and D.
Well, A is part of it, but it is D, A and B. You always have to send it to ODNR for review if they want it or not. They usually never get back to us and the 14 days expires and we go ahead. ODOT Office of Facilities is not in this because we are not disposing of a facility. This is actually a road. Fill in the blank. Owners whose place of residence is unknown or who are non-residents of the state are blank in the notice of publication.
This one's a little longer than just typing a single letter.
Yeah.
Okay, somebody has to know the answer to this one.
This one's a little hard since it's.
I got a question mark. That's good, guys. All right, nobody's, persona non grata. Somebody said no idea. Somebody else said.
This one's a little hard, but it is the owner whose place of residence is unknown or are non-residents of the state are specifically named in the notice of publication. You have to call them out in the notice if they are unknown or out of state. Number 8, in a highway vacation, upon satisfaction of all damage claims, either through negotiations or court actions, the district will prepare and execute this for each parcel being vacated.
This one's better. We're back to single letters here.
Yeah.
Even though the last answers were pretty creative. Everybody's picking E here.
Man, everyone is very smart. It is E, both A and B, Highway Vacation Instrument Form RE 74-42 and Settlement and Release of Claims Form RE 63. You would only have the Form RE 63 if there are damage claims. So if there are no damage claims, you wouldn't have to use that. Fill in the blank. If there are no damages to the abutting owner as determined by the district, then you would not proceed with the action as a highway vacation. Instead, you would either blank fee owned or blank an easement.
Better get their typing fingers out. Somebody said sell or extinguish. See what else comes into the box. Okay, somebody else answer. You guys are creative with your answers. Question mark / extinguish. I'll let you call it when you want to.
Okay. For the most part, you're right. If you own it in fee, you would sell the property. If you just own an easement, you would just extinguish it. Pretty straightforward. So if you own the fee, you can sell the property and all the rights. If not, if it's just an extinguishment, if it's just an easement, we would just extinguish it. Number 10, true or false? Easement extinguishments are at no cost to the underlying fee owner, and on vacations, you may end up having to pay damages to and up to and including relocation benefits.
We got one true in already. A bunch more just came in too. Everybody's saying true.
Well, you guys are great listeners because it is true. If we are extinguishing an easement to someone, we extinguish it to the underlying fee owner. We do it at no cost. Number 11, when extinguishing an easement after all necessary approvals have been obtained, both in-house and external, the district will prepare and record a
C has come in a couple of times, 3 times. Yep, everybody's saying C.
C is correct. You would fill out the Extinguishment of Easement Instrument Form RE 63-1. We have a lot of forms that we've gone through that we've talked about, and you can always find them on the ODOT real estate website. And they do change occasionally, so don't save them to your desktop and just pull off that one. Go to the actual website and get the newest version, just in case. Number 12. After all vacations and extinguishments are concluded, the district must
Everybody's saying D, like dog.
D is correct. You would obtain all recorded, or you would obtain a recorded copy of the instrument for their files, update all right-of-way plan sheets to show the vacation or extinguishment, and report to central office quarterly of the land deletions. And with that, I am going to pass it off to Scott Recker.
Okay, Scott, things are switched over to you.
Okay. Okay, we're going to talk about limited access modifications and the bundle of sticks, real property concept. Here you see a bundle of sticks, and it shows different property rights for those properties. It could be timber rights, right to build homes, mineral rights, access rights, and the right to sell your property. Today, we're going to be talking about, with the limited access right-of-way modification, we'll be talking about access rights. An LA unlimited access modification is really a disposal of ODOT's ability to limit abutting property owners' access. We are conveying back to the adjoining owner a right to access the roadway. Once the ability to limit access is acquired, ODOT prefers not to dispose of it. However, in limited circumstances, ODOT will allow a limited access modification. Every limited access modification includes conveyance of necessary access rights and issuance of a highway use permit, MR 509. The instrument conveying the access control is recorded at the county recorder's office as evidence of the property right transfer. By law, ODOT can and will charge for selling property rights. The permit is issued to authorize and describe the construction work to be performed within the right-of-way. Also by law, ODOT may not charge for a permit. The Office of Roadway Engineering State Highway Access Management Manual has more details on access control and the issuance of highway use permits. We used to have a permit application, MR 505. Now all of our permits are done electronically. So if you have issues with permits to modify limited access right away, check with your permit people in your district. They could vary of who they are in each district, but it's now electronic and you have to go through those avenues. ODOT's policy and procedure section 8100 also provides guidance on permits. Determining existing access rights. During the initial consideration of a request for an LA modification, as well as during enforcement of access restrictions, it is necessary to determine the use and width restrictions of any existing legal access point. In making that determination, the instrument through which ODOT acquired the right-of-way is generally considered the controlling document. You must read the deed or instrument to see what it specifies. With a lot of our older acquisitions, the instruments may specify that the state acquired all rights of direct access except as shown on highway improvement plans. So therefore, there are times when these plans and profile sheets and right-of-way sheets graphically show a drive, but do not have a labeled width. In these cases, it's possible to determine the maximum allowable access width by either scaling the drive width or referring to standard construction details. Some common widths that are used are 10-foot field drives, 12-foot residential drives, and 20-foot commercial drives, not including the turning radii. The valuation of a limited access modification. The appraisal section of ODOT Policies and Procedures Manual at section 4500, non-eminent domain valuation, details the valuation process for limited access modifications. In some instances, an appraisal is not required if it is apparent that there will be no change in the intensity of the highest and best use by modifying the access of a property. So if you have a request for a limited access modification, you'll be required to do a highest and best use analysis and write-up to determine if there is a change in highest and best use. The highest and best use analysis, it says here, is in your handouts, but we can discuss it more later in the module. I don't know if there's examples of that out on the website, but if anyone would like an example of a highest and best use analysis, they're more than welcome to contact me, and I have some examples that I can forward to you. When applicable, the fair market value of an LA modification is established by an appraisal that considers the value of the property without the new access and the value of the property with the access. The difference is the enhancement value of our access modification, less any necessary zoning change costs, utility costs, construction costs, and entrepreneurial profits. These can be quite expensive, and commercial business owners often have sticker shock when they do not anticipate these costs. We've had LA access modifications. I've heard stories of up to $1 million, depending on what kind of a property it's opening up that was landlocked before and will now have access. When processing LA modifications, in addition to the normal reviews and approvals for any property disposal, the district receiving the request for an LA modification will secure a statement in writing from the requesting owner containing the location of the property, an identification of the limitation of access to be modified, a statement on the planned use of the property to be served by the newly modified access. All this is important as you need to know what is going to be developed so district staff can determine the impacts to the highway and the through traffic. Regardless of how ODOT owns the limited access rights, whether we own it in fee or easement, an owner of a parcel receiving a limited access modification will be required to pay the full enhancement value of the modification as applicable. So it doesn't matter if we have an easement limited access or if we own it in fee. If there is an enhancement, that owner is responsible to pay for that enhancement, whatever the appraisal shows it to be. A written before and after appraisal stating the estimated amount the abutting property will be enhanced by the proposed modification is normally not obtained until district has reviewed and conceptually approved the request. When applicable, we discussed the FHWA stewardship agreement. When applicable, and we discussed the stewardship agreement back in Module 1, the appraisal and all supporting documentation must be reviewed by FHWA. When a request for a limited access modification is granted and the fee owner concurs in writing with all conditions and costs, the district will modify the existing LA by executing an access grant instrument that conveys the modified access rights to the abutting owner while simultaneously issuing a highway use permit. Here's an example of an access grant instrument and its associated highway use permit. Here's the first page and the signature page. The first page of it and the signature page. Some specific items that we'll look at, and there's a signature page and the exhibit. So some specific items we're going to look at. First, there will be a clause that describes what's happening. In this instance, a Dollar General store wanted to move and widen their existing 20-foot commercial drive to a 36-foot wide drive. Here we see ODOT reviewed the application and agreed it can be moved and widened without impacting the integrity of the roadway. Here too, you can see that the district did a highest and best use analysis and determined there would be no enhancement value charged. Of course, if there was an enhancement value, it would be identified here. And finally, this is an excerpt from the legal description. After all the calls and distances, you get to the point of beginning. The access grant calls for a 36-foot distance down the right-of-way to show the extent of the access grant. Now we'll look at the actual highway use permit, MR 509, that was issued in conjunction with the access grant. Highway permits are issued to allow work within the right-of-way. By law, we cannot charge for permits. Permits do not convey a property right. That is why we must use these in conjunction with an access grant instrument. Permittees must keep the permit with them at all times during construction as proof that we have granted them the right to put in the driveway and any corresponding improvements. So let's look at some details in that permit. First, as we discussed, this permit is what allows the construction within the right-of-way. And you'll see on this one, it allows for stormwater drainage connections within the right-of-way, which doesn't have anything to do with the access modification. So permits can cover different things than just a new drive. We issue permits for all kinds of utility work within our right-of-way, etc. Next, we see the permit must be maintained on site by the job foreman, and further that all plans and specifications the permit is based upon are maintained at the district office. And finally, the permit is signed by the director or their designee. And there it shows where it's maintained on file and then signed by the director. Here's one of the plan sheets that the developer provided the district with their application. As you can see, 3 drives are all 12-foot wide. When added together, makes the 36-foot access modification. And here's what the finished store and its access drive look like on Google Earth. And this is what it looked like from the roadway. And it all started with an access modification from ODOT because we own the right to limit access to the roadway. So this was one that was actually done that I did in District 1 myself. And these are common where you have an existing access point that may be narrower than what is wanted by the abutting property owner. So they already have access, they just want to modify that access in some way. So those are pretty common and fairly easy to go through. It's when you are issuing taking a property that is landlocked and giving it access that you really give it an enhancement value that they become fairly complicated. So for processing final processing of access modifications, payment of the value of the limited access modification will be received by the district at the time of closing. The district will maintain a copy of the recorded instrument and update necessary right-of-way plans to show the access grant conveyance. And again, I don't know if there's any questions, but if not, we can move on to a case study.
There are no questions in the question box right now, so that would be great.
Okay. So here's a case study that we have, 4.2. We'll just kind of go over this together. Normally in class, you would work in a group and come up with some answers, and then we could discuss, but in this setting, we'll just do it this way. So you can see here the plan sheet. The area in green is the area we're talking about. It is owned by actually Walmart, and what they would like is, if you can see the little area in blue right here, that is where they would like to put a driveway across limited access right away. And here's what it looks like with the access point constructed. You can see the new drive is opposite of the North Distributor Road, which I believe is right here. So they lined it up with this road. This is the Walmart here. There's a McDonald's there. You can also see that Walmart built a drive to the north up in this area, across from the Fairgrounds Drive. This was outside of our limited access right away. This is kind of what it looks like from the roadway. There's the McDonald's, and behind the McDonald's were those access points. So the review learning outcomes, first of all, we wanted you to understand how ODOT controls limited access right away. We discussed the bundle of sticks concept in real estate and how and when ODOT acquires limited access right away, it is purchasing the right of an adjacent owner to cross over our right of way boundary and onto our highway. We also discussed that when ODOT acquires limited access right of way, the abutting owner's access is specifically identified in the instrument, easement, or deed. Next, we discussed limited access modifications and how they are really the disposal of ODOT's ability to limit the abutting owner's access. Every limited access modification includes conveyance of the necessary access rights and issuance of the highway use permit. Every limited access modification, we're doing that. Oh, let's go back one. Every limited access modification includes conveyance of the necessary access rights. The instrument conveying the access control is recorded with the county recorder's office. And by law, ODOT can and will charge for selling property rights. Again, if it enhances, because if you really think about it, when ODOT acquired those rights, we paid for those. Anybody that's been part of acquisition for very long, if we've done limited access acquisition and you've landlocked property, you know that we pay fairly large sums of damages to property owners to landlock or take away their access. So if at a further date they would like us to give them that access back, it's only right that ODOT would recoup some of those damages that we had to pay to get that right. The permit is issued to authorize and describe construction work to be performed within the right-of-way. Also, by law, ODOT cannot charge for a permit. That's why we do the modification and the grant, so that if we have to charge, we can charge with using that access grant. We also discussed how the acquiring instrument determines the existing access, if any, and how you must read the documents to see what it says. On older acquisition, the instrument refers to the right-of-way plans, which will spell out the access points and widths. And in some even older acquisitions, you must scale the access points on the plans or refer to standard construction drawings to determine the owner's permissible access. We also wanted you to know when to obtain an appraisal. In some instances, an appraisal is not required if it is apparent there will be no change in the intensity of the highest and best use by modifying the access of a property, but that will require a highest and best use analysis write-up. When applicable, the fair market value of a limited access modification is established by an appraisal that considers the value of the property without the new access and the value of the property with the access. This difference is the enhancement value of our access modification. From this, we deduct any necessary zoning change costs, utility costs, construction costs, and entrepreneurial profits. There have been times that we have given people access, property owners access, and there's been large enhancement values, but because they're going to contribute large amounts of money to construction of maybe a turn lane or a new interchange or things like that, that those values are taken away from that enhancement, and they haven't had to pay the large enhancement value, but they have contributed that value in other ways to the project. And finally, we wanted you to know how to process and finalize access modifications. In addition to normal reviews, you need to secure statements from the requesting owner on what they want modified in their plans. You'll need to determine if an appraisal is needed, and then you'll seek FHWA appraisal or approval as necessary. To finalize it, you will draft and have signed an access grant instrument while issuing the highway use permit. We reviewed these documents in the module and went over a few details in each. As part of the closing, you obtain and process any payments. You will make sure the instrument gets recorded and all right-of-way plan sheets get updated to reflect the modification. Okay. Little quiz that we have here at the end. Number one, true or false? Under the concept of the bundle of sticks in real estate, access rights cannot be split off and conveyed away from the warranty deed fee interest in the property.
Whole bunch of F's rolling in.
False is correct. We talked about those bundles of sticks, so there are many of them, and one is property access rights. Number two, to determine ODOT's limited access rights, one would use A, B, C, D, or E.
Waiting for a second to see how many people respond here. Because it seems like they're all getting it right. Yeah, they've all put down E.
And E is correct. We have a lot of instruments and plans that you can look at to determine this. And like it said, a lot of our older plans will call out an access point. It'll have an actual station along the center line, and it should tell you the width of that drive. Number three, true or false, an limited access modification is really a disposal of ODOT's ability to limit the abutting property owner's access. We're conveying back to the adjoining owner a right to access the roadway.
They're all putting T for true.
And you are correct. It is true. We are disposing our ability to limit the abutting owner's access. If sometime in the future we need to limit access again, we would have to reacquire that access right. Hopefully we never have to do that. Number four, when a district grants a limited access modification and conveys the necessary access rights to the abutting owner via an access grant instrument, they will also simultaneously issue A, B, C, or D.
Okay, we're getting a little bit of a mixed response here. Looks like the majority of the people have chosen C like cat, but there's a couple who responded D like dog.
C would be the correct answer, highway use permit. So in addition to the access grant instrument, we have to give them the use permit, and the use permit allows them to construct that driveway within our right of way. We're giving them an access right, but ODOT still owns the right of way. We're just giving them a point of access. In order for them to build their driveway, they have to do work within our right of way. So we have to give them that use permit to allow them to do that. Number 5, true or false, per revised code 5501.34 and 5501.45, ODOT can and shall charge for selling their property rights to private individuals.
Everybody's saying true on this one. Oh, one person said false.
It is true. So we can and we will charge for an enhancement value of giving that right back to someone. Again, like I stated earlier, remember, we acquired that right. We paid for that right through damages or through our acquisition process. So when we give it back to them, we have the ability to charge them for that right back. Number 6, fill in the blanks. At ODOT, common historical widths for drives depicted on plan sheets, not including turning radii, are blank are blank foot field drives, blank foot residential drives, and blank foot commercial drives.
Okay, lots of folks are typing in, and majority of them are saying 10, 12, 20, even though we had one that said 10, 12, 24.
It is 10, we'll put it here. It is 10, 12, 20, but I will tell you that in District 1, we're a very rural district, and you have probably seen the size of farm equipment, and a lot of farm equipment is now done with semis and really large tractors and combines and stuff. So the 10-foot field drive has gotten a little bigger, and a lot of commercial drives. In our example, we had one that was 36 feet. So this is kind of a standard, but there are a lot of differences in that. That's why you need to look at the instruments, the legal descriptions, the plan sheets themselves. If nothing says it, that's when you would rely on the ODOT historical widths and try to come up with what that is. Number 7, true or false, per revised code 5515.01, ODOT can and must charge for a permit.
Lots of F's coming in, even a double F. We got one true though.
It should be F, false. We cannot, and I said that several times, we cannot charge for a permit. That's why we use the access grant. That's where we have our charge for on that. We don't charge for the actual permit. Number 8, fair market value of a limited access modification is established by an appraisal that considers the value of the property without the new access and the value with the access. That difference is the enhancement value of the access modification less A, B, C, D, or E.
All right, we got a bunch of E's and one C like cat.
It is E, all of the above. So if the property owner has, when they go to the zoning board and they have to pay a bunch of money for permits and maybe to get a zoning variance or something, they can use that. If they have utilities to get connected up, they can use that. Construction costs, entrepreneurial profits, they can deduct that all from the enhancement value. Number 9, in some instances, an appraisal is not required if it is apparent that there will be no change in the intensity of the highest and best use by modifying the access of a property. In these instances, the district will prepare what in lieu of an appraisal? A, B, C, D, or E?
Well, we have one person said E, quite a few people said B, but we've got some C's. Mainly all Bs though.
B is correct. You do a highest and best use analysis write-up. And if any, like I said earlier, if anybody has or would like an example of one of them, please contact me. I'll get one over to you. But basically, the write-up will say what the current use of the property is, what the property is zoned, those types of things. And then in the after, once it has access, what the highest and best use could be, and what the property owner is proposing its use to be, and you can come up with if there's a change in the highest and best use. A lot of times, if all you're doing is modifying an existing access, in other words, a property owner already has access maybe off of a county road or has access further down the road, and they just want one around the corner that happens to be limited access, those may or may not have a change in highest and best use. If it's a property that has absolutely no access and they're wanting access, more than likely it will have a change in highest and best use, and you'll need an appraisal for that one. True or false? Last quiz question. Both access grant instruments and highway use permits are only to be signed by someone authorized to sign on behalf of the Director of Transportation.
They all knew this
So
when
who signs those?
the T's are rolling in.
It is true. If you guys have not learned anything else, at least you know for sure that basically, for the most part, all of our instruments must be signed by someone authorized to sign on behalf of the Director of Transportation. If you are not authorized to sign on the behalf of the director, please do not sign them. All right. That pretty much wraps up what we have for today. Here is Tyler's contact information. I believe, am I correct, Victoria, they have a copy of today's presentation in their handouts?
They do. It's in the handout section of the GoToWebinar panel, and I'm also going to email it out afterwards.
Okay, great. So there's Tyler's information and there's mine. If you guys have any questions, or if in the future you're doing any property management functions and have a question that comes up, please feel free to contact Tyler, or you can always contact me too, and I'll help you any way that I can. Thank you very much. Tyler, did you want to step in and close it out?
Yeah, as Scott said, we have examples of every form that we've filled out or that we've talked about here. So, and we have examples for many different situations, unique samples of the forms. So we can probably get you something to get you started down the right path. So you might have to do a little work, but we'll get you started. Thank you very much for attending these 4 days. I hope you learned a lot, and feel free to ask any questions that you have.
You guys have provided fantastic information. Thank you so much.
Thank you, Victoria.
I don't see any other questions in the box, just lots of thank yous and kudos rolling in for both of you. So if you do have any further questions, though, you'll have the contact information for your presenters, and we thank you for your time on this webinar series. So we look forward to hosting you again. Everybody take care.
Thank you, Victoria. Thank you, Scott.
Bye-bye.
Thank you, Tyler. Bye-bye.